Thank you.
Next case is Village Inn Bar and Grill versus Brown.
Well, that should shorten things up a little bit.
He didn't expect to stay there for 56 seconds. We know you didn't reasonably expect the state to take 56 seconds on their argument, so it's understandable.
May I have 7 minutes for rebuttal?
All right, when the yellow light goes on, you'll be into your rebuttal.
Thank you. My name is Ted Schott. I'm here on behalf of the appellant, the Village Inn Bar and Grill, Inc. We are appealing today a order of partial dismissal and an order of judgment on the pleadings. There are actually 3 orders that comprise those 2 findings. The way in which this went was an order of dismissal, a motion for reconsideration, an order on that reconsideration, which was partially vacated, the original order, and then a final order on the judgment on the pleadings.
Can I just ask a preliminary question? There's a lot of references to the plat of the subdivision that allegedly dedicates or creates Florida Avenue. Is that plat in the record anywhere?
In our record today, it is not. It is an unrecorded plat. However, the complaint makes allegations.
Right, I understand the allegations, and I found a diagram in the record that I had some problem following, but the plat itself is nowhere in the record. Is that correct?
Correct. The plat is an unrecorded plat that the only real record of it outside of our record would be a historical map that Sumter County keeps, which is over in the property appraiser's office there.
So nobody really has the plat anywhere.
The plat, again, is from 1963. It was an unrecorded plat, so when you go...
Just so I'm trying to envision in my mind how the properties here relate to one another, and it's my understanding that your contention is that your property or your landlord's property was not contained in the plat, but was adjacent to Florida Avenue. Is that correct?
That is correct, Your Honor. It was all part of a master parcel to begin with.
Right, I understand it all started, but assuming your theory, assuming what you've alleged in your brief, your allegation is that your property was not contained in the plat, but was adjacent to the plat. Is that correct? Adjacent to the platted property.
I would rephrase it from that, Judge. It was originally part of the parent parcel. The plat was then established, creating Florida Avenue, and then the commercial property that fronted 441 and 27 was sold based upon an unrecorded plat that was known at the time to have Florida Avenue running as a secondary access point for the property.
And when you say that the property was sold with reference to the plat, what you're telling me is it would say like, what, lot 10 east of Florida Avenue or something along those lines?
No,
is that how it referred to Florida Avenue? It
was sold by meets and bounds description, I believe, Judge, without reference to the plat, but the plat was already in existence so that any purchaser who was buying knew that there was an offer to dedicate a road behind this commercial property. Essentially what you have is...
How'd they know that if it was an unrecorded plat? Where was
Because
that?
it was sold, lots within the subdivision were sold subject to the plat.
Okay, but your particular lot, if I looked at your deed, it would not make any reference to the plat or to Florida Avenue. It's got a meets and bounds description.
I believe that's correct, Judge. I actually believe it may have a description to the commercial strip that was then platted. So what happened is the back half was platted as residences under the Lake Weir property, and the front half from Florida Avenue to 441 was divided into, I think, something along the lines of 20 very small parcels along 441, and I believe the legal description will make reference to that commercial development from 63.
Good, thanks.
It sounds as though I don't need to go into the facts of this case. You appear to have a handle on them. What we're dealing with is a rectangular piece that was transferred from the original developer to a commercial developer on your side, being the east side. I believe, if I've got the orientation of this building correct, would be Florida Avenue. On my side would be 441.
Let me jump right to an issue that is kind of in my forefront, and that is the effectiveness of the abandonment of Florida Avenue by Sumter County. Your contention is that because Sumter County's resolution did not make a finding of public necessity, that it's void. And I guess I have two questions about that. Number one is, when I look at the statute, it has two requirements: that the county shall have a public meeting and shall give notice, and there's no requirement in there that you find. I understand there's some language in that first district case. So the first thing is, you know, is the first district right that is a requirement? And the second question, I suppose, is why in your mind, even if that is a requirement, that there be a finding of public necessity, or public benefit rather, why does that render it void as opposed to merely voidable? I understand you make that argument, but I'm trying to understand where the precedent, what's your argument that supports this idea that it's void? So let's start first with the clear wording of the statute only has two requirements.
When any police power of the state is exercised, Judge, it is abused unless it is exercised for the promotion of the public's health, welfare, safety, and morals. That is the principle that both the Attorney General and the first DCA in the Bolden case from 1991 premised their decisions that if you are going to vacate a road, the power to vacate streets cannot be exercised in an arbitrary manner without regard to the interest and convenience of the public or individual rights.
But isn't there a presumption that public bodies act in the public interest, and wouldn't it be your burden to demonstrate how this was opposed to the public benefit?
Well, both the Attorney General and the first DCA have ruled that absent a determination by the County Commission that general public welfare would benefit from the vacation should not be accomplished. So I don't believe it's our burden to prove that it's contrary. I believe it's their burden to make a determination at the time that it is in the public benefit. The Bolden case, the first DCA, went on to say whether the county's decision to vacate comports with the best interest of the public at the present time or is merely an arbitrary act that fails to conform with the statutory intent governing road closings is sufficiently raised in the complaint for declaratory action to warrant an evidentiary hearing thereon. And that, to me, is the cardinal error that we have here, Judge, to go back a little bit. This action is one for declaratory judgment. The standard of review that this court has on declaratory judgment action, as determined by this court in Wildflower in 2015, is abuse of discretion. However, a ruling on the merits should not be made until after a final hearing where the parties have full opportunity to present evidence in support of their respective positions. That is the position that has been taken by the first DCA in Mills, the second DCA in Appel, the third DCA in Government Employment Insurance Company versus ANTA, and the fourth DCA in Effort Enterprises of Florida versus Lexington Insurance Company. And what we have here is The court went beyond the issue of, do I need to have a hearing to allow these people to tell me what they want me to decide in this declaratory judgment, or do I simply go to what the allegations are and whether they can prove them or not and make a determination on that basis?
Well, but doesn't that then bring us to the second question, which is, if it's void, then I would probably agree with you. If it's merely voidable, assuming that's a requirement at all, if it's merely voidable, then that presents a different universe of problems because of the statute of limitations. So my question then is, what's your best authority for the idea that this is a void action as opposed to voidable?
Judge, in Seaside Properties, Inc. Versus State Road Department, the third DCA in 1966 was faced with a dispute over ownership of an allegedly abandoned road. And the situation there was that Seaside wanted to claim ownership of a road, and based upon maintenance, the government said, hey, no, that's our road. What ended up happening was the court made it very clear, if the statutory procedure is not followed, the road is not abandoned nor closed. In addition, Judge, we have the
What was the procedural defect in that case? It wasn't a failure to have findings, right? And
it was the argument that the road had been abandoned, and it was based upon the testimony of a road engineer. There wasn't actually any formal act taken by anybody to abandon. But nevertheless, the court said, you either follow the statute or you still have an open road.
Right? You either follow the statute or you have an open road. And to follow the statute are those two factors that Judge Orfinger referenced, right?
No, Your Honor. The statute implies the authority of the government to act. The statute says how the government is to act, but you cannot have a statute that is contrary to constitutional principles, that the act has to be in the public interest. In addition, we have Boy's Work, which is a first DCA case from 1975. In Boy's Work deeded property to the government for a road. Thereafter, Boy's Work asked for the property back. Apparently, the government was confused about how that was going to work, issued a deed. The meeting minutes show that they immediately directed the clerk to go ask for that property to be sent back to the government because of confusion. What the court determined in Boy's Work is that a void deed, because it did not follow the statutory procedure, is void. And the argument that was specifically made in Boy's Work that it was cured by Section 33611 of Florida statutes, and that the actions of St. Johns County is barred by Section 9523, the statute of limitations. And the first DCA determined that as we hold the deed as void, we also hold the curative statute and the statute of limitations are not applicable to a void deed. The point being, it's void ab initio. It, from the time it was executed, was never effective, and nothing will breathe life into it coming forward. The cardinal error, again, is getting to the merits, and the merits being, is the Sumter County resolution valid or not? That is something that should be decided after a full hearing. In addition, we have numerous situations.
Isn't it potentially a legal issue that doesn't require an evidentiary hearing? If your argument is a resolution that doesn't include those findings is void, why do you need an evidentiary hearing for that if the court has the resolution in front of it?
Because if the court is going to follow Bolden from 1991, where the court again looked at whether the abandonment of a road was proper, the court determined that a declaratory judgment hearing was warranted based upon the allegations that the road was not closed properly. The issue that we're getting to now would be a statute of limitations issue, but the statute of limitations issue is addressed by Boy's work, where a deed essentially, or a transfer of right to property, which is what we're dealing with in a road closure, is not governed by a statute of limitations argument. So by getting there before holding any facts, the court got ahead of itself according to the first through fourth DCA.
If we don't agree with your argument and we were to determine that the resolution was indeed valid, other than your argument about does your landlord own the property to the middle of the road, do your other issues go away? You can no longer have your easement by prescription argument if the resolution is valid, correct?
I think, Judge, there is a potential additional argument that I have not explored, but that is in Downing. The public may acquire an easement in land separate and apart from the rights of a city and in spite of the actions of a city. So in that event, you have a situation where the city was collecting taxes on property, and the owner argued that because of the collection of taxes, there could not be an argument that that was public property. And what the court determined was, no, that's something to be considered, but that's not determinative. The same issue may apply here. If this court were to determine that the resolution is valid, the testimony or the facts as we understand them is that the Florida Avenue has been used continuously. I don't want to get into hypotheticals as to what may be proven, but there may still be an issue based upon the Downing case as to whether it was in the best interest of the public to close the road, and whether the public's continuous use, despite what the county did, allows for the public to continue to use that road.
That's not an argument that you made below.
Correct. I was being asked a hypothetical by Judge Palmer.
If the resolution is valid, are you now doing away with your argument that your client owns to the middle of the roadway?
The resolution is not valid, but to the extent the court determines that it is valid, no, we would still be entitled to a determination in a declaratory judgment as to what the ownership should be.
Don't you first have to show that the property was vested in the county?
I think, Judge,
36.12?
looking at Calvert, first DCA from 1993, there was a dispute over a 30-foot right-of-way dedicated to the city of Jacksonville for drainage and utilities that lay between two parcels. One was part of the original plat that identified the drainage easement, and the other was not. And in that court, it was determined that, yes, there should have been a declaratory judgment on that issue, and second, that the property should be split between the two. As to the issue of whether the property is the county's to get rid of, that goes back to the issue of, was there a common law dedication and is there a public prescriptive easement, which I have not yet had time to address, but the court got the law wrong on both of those in its application. In the public prescriptive easement, he indicated that a private right to prescriptive easement was required to claim a public prescriptive easement. The 12-foot strip that's at issue in that order is property that is part of our rented property. There's no need for a private prescriptive easement over it. However, there was a need.
If you want to save any of it for rebuttal.
I just want to finish these 2 points. The need to describe the 12-foot strip was to show the special injury in that we had access to Florida Avenue that was being deprived and our property value was being diminished, which shows the special injury, which gives us standing. The second issue on common law dedication, the court got it wrong on acceptance, saying that it had to be a recorded plat. Numerous cases have been cited to this court for the purpose that an unrecorded plat that sells lands thereto constitutes an offer of dedication, and use by the public alone is sufficient to constitute an acceptance of that dedication. Thank you.
You got about 2 minutes for rebuttal.
May it please the court. My name is Christian Waugh, and I represent appellee Ronald D. Brown in this case. I'll be using approximately 15 minutes of the allotted 20 or 17 and allowing 3 for the attorney for Sumter County. Despite a lot of the real property doctrines that we've heard about today and in the briefing, Your Honors, the sole issue before this court is actually pretty simple and narrow, and that is, did the trial court abuse its discretion in finding that appellant is not entitled to a declaration of its rights regarding, first, a public prescriptive easement, and second, common law dedication?
Let me ask you this. The court said that he stated a cause of action, correct? He ultimately ended up denying your motion to dismiss and said he stated a cause of action for public prescriptive easement and common law dedication, but then on those same pleadings granted judgment on the pleading, which to me seems a bit inconsistent. I mean, in a judgment on the pleading, say you can't possibly state a cause of action on something that the judge already said you just stated a cause of action on. I mean, it seems to me that procedurally you maybe should have pushed the ball down the court a little bit to a summary judgment or something, but I'm a little concerned about the procedural aspect that if the judge was right that he did state a cause of action, how he failed to state a cause of action for judgment on the pleadings purposes.
I think this court should be concerned about that. The reason why it occurred that way is because there was a substitute judge on one of those orders. Most of the orders that are here under appeal are by Judge Hallman, and one that found that there was a tenuous cause of action for ingress and egress for golf cart access was from Senior Judge Johnson. And so that's why I think there's a little bit of disparity in how the orders treated it, but ultimately I also
It seems to me that one of them is going to be right and one of them is going to be wrong.
I think so, Your Honor, and I think
You know, I'm just conflicted by the procedural posture of the case for that reason.
the order on the motion for judgment of pleadings is correct in that they were unable to state a cause of action for public prescriptive easement because the only thing that was at issue at that point was a public prescriptive easement for ingress and egress for golf carts. And they failed to state under...
Why is the golf cart? I mean, I understand it's the villages and golf carts are a big deal, but in the world of transportation, does it make any difference if it's golf carts, motorcycles, cars, or horses? I mean, they either have an easement over it, and if they have an easement over it, does it make any difference whether it's for a golf cart or for an automobile or for a horse?
I don't think it does, Your Honor. I think that the functional point of the holding is that it has to be a specified use, which would be ingress and egress. I don't think it matters if it's horse or golf cart.
So I guess I'm trying to understand what's the distinction. Why do we care about golf carts? I mean, I know in the villages everybody cares about golf carts.
Oh, boy, do they, Your Honor.
Why do we care about golf carts?
I don't think this court does care about it, except that the only reason they were able, under their own argument, to state a special injury that would give them some kind of standing to state...
But that's not the special injury they were alleging. I mean, they were alleging a special injury because of the improvements that they made, and they weren't just like... It wasn't like I brought the cause of action because I might someday want to walk down Florida Avenue. They said, well, we rented this property, we checked it out, we determined there was public utilities there, that sort of thing. So, I mean, I'm not sure that their access argument and their special injury argument aren't two different things.
I actually disagree, Your Honor. I think under the record, what they're alleging for their special injury is that because of appellee Ronald D. Brown's obstruction of ingress and egress, they were unable to get the golf cart access through their public prescriptive easement.
Let me ask you to jump to the end, and let's assume for the sake of my discussion a couple of things. Number one, that the resolution of the county was valid. And number two, that we accept the opposing counsel's argument that the adjoining property owners would own to the center line of what's been referred to as Florida Avenue. I understand that's not your position, but assume that. Does that still leave them with a gap? I mean, doesn't that mean that your fella owns at least at a minimum half of Florida Avenue? And that still leaves them with I mean, they gotta have a helicopter or a pogo stick to get over that part, don't they?
We don't know on the record, Your Honor.
Well, but as a practical matter, I mean, essentially, they've alleged you're on one side of Florida Avenue and they're on the other. So if they're correct, and I'm just, that's a hypothetical. If they're correct, and the road was abandoned and the adjacent property owners own to the center line, that means your guy owns to the center line of his half of the road, and so they still have a problem, don't they?
Well, that's correct, Your Honor, especially if the utility easement is beyond that halfway point. If where the utilities easement is 1 foot away from the edge of the property, then they might be able to get access under that center line argument. On the other hand, if it's 15 feet away and it's on Ronald Brown's side of the center line, then they wouldn't have access to the utility easement, and they're still left with that problem.
And the record doesn't say where it is?
No, Your Honor. However, there are other reasons why they failed to show an entitlement to a declaration of rights for public prescriptive easement. Setting aside the resolution for a second, which I think is obviously valid, they don't stand in the shoes of Sumter County, and typically under Supel, a 5th DCA case, 455 Southern 2nd 593, quote, "It is generally a legally organized political entity such as a city or county which represents the general public and establish of that public prescriptive
It
easement."
doesn't say you have to be a public.
It says generally, Your Honor, that is true.
It doesn't say you have to be.
And, no, Your Honor, it doesn't. And however, I'd also add on to that here we actually have the county, Sumter County, kicking and screaming, saying, we don't have a public prescriptive easement. So I think factually it's even stronger than Supel here, saying they just don't have standing to do it. I mean, if there's a difference or an argument as to whether or not a private person or a county arguing who has standing to fight over whether there's a public prescriptive easement, I'd argue to this court every day and twice on Tuesday that it's the county that has that standing, not the private person. And then common law dedication, they also failed to show an entitlement to a declaration of rights on that point, insofar as the 3 elements are intent to dedicate a property to public use, acceptance of that offer, and under a Florida Supreme Court case that was cited in the 4th amended complaint actually, that acceptance need not immediately follow the offer to dedicate, but it must be within a reasonable time. Under the facts as alleged in this complaint, we have an unrecorded plat from the early 1960s. We have a fire hydrant 40 years later that appears. We have an alleged 911 map. I have no idea where it is, but a 911 map 40 years later. It's hard, and I don't think it would be an abuse of the trial court's discretion, certainly not clear error, that to find that that wasn't within a reasonable amount of time. Now, the court's orders didn't refer to that element, but I think that this court is entitled to consider it under the Tipsy-Coachman rule. In any event, again, this is an issue where Sumter County would have the standing to actually get that common law dedication. What we have before this court is a battle between a private entity saying, no, we want the common law dedication, and the actual county itself saying, no, not only do we not have it because we passed a resolution, we don't want it. The Florida Supreme Court also said, quote, "The burden of proving acceptance of an offer to the public to dedicate lands for streets is upon the county or municipality asserting it." That's from their Florida Supreme Court 1920 case, Miami v. Florida ECR Company. And I think the court might point out again, well, it doesn't say that it must be the county. But we have a case here where the county is saying they don't want it and they don't have it. I think that...
So you're saying the county never accepted the roadway?
Clearly not, Your Honor.
So is the situation where they closed the roadway, it was just through their procedures, doesn't that at least show that they, in the past, may have accepted the roadway?
No, Your Honor, insofar as, I mean, the reason why the resolution makes no finding as to ownership, it makes no finding that they actually had rights. It's kind of like a quitclaim deed. A quitclaim deed renounces any rights that someone might have in it. This resolution just vacates anything that might exist there. There's no whereas or finding regarding that they do have these rights. They're just saying that they're renouncing what they've got. And that makes a lot of sense since Appellee Ronald Brown owns the property in fee simple. And the resolution is on both declarations of rights, probably a quote-unquote kill shot. Appellant is stuck with this thing. The resolution was never challenged. It was passed in 2002. It doesn't violate any of the clear provisions of the statute, number one. Number two, under actually Keenan v. City of Edgewater, 5th DCA case from 1996, very similar facts. There was a resolution passed by a governmental entity, and it imposed special assessments without addressing whether or not the resolution was constitutional, without addressing whether or not on the merits the resolution violated procedure. This court found that because the resolution was passed in August of 1991 and suit was filed on December of 1995, over 4 years past the time to challenge that resolution, that the 4-year statute of limitations period applied. So a lot of the arguments that this court is hearing about the resolution are things that can and should have been raised by appellant back in 2006, especially if they stand in the shoes of the landlord for the purpose of this action. And they didn't do that.
If there were a common law dedication, what are the legal implications of that for the county? I mean, is the county obligated to maintain it? Are they liable if somebody's injured on it, or do those things flow if there's a common law dedication?
Yes, Your Honor, and that is part of why the county should have primary standing for dealing with it. If liabilities can and will arise, and the county doesn't want them and has disclaimed them in the past, I think it would be unjust, and I won't speak for the county, but I mean, I think it would be unjust to allow an individual to impose those burdens on the county, especially given the evidence on the record. And because appellant has failed to demonstrate an entitlement to a declaration of rights for both public prescriptive easement as well as for a common law dedication, for multiple reasons, I think that also implicates doctrines of harmless error, Your Honor, in that if, for example, this court doesn't agree with me that they failed to allege the elements of a public prescriptive easement. In other words, they didn't show the use in their complaint. They didn't show the 20 years for ingress and egress. Then it's not reversible error because it's harmless, because they don't have standing to pursue it. And the resolution acts in any event to prevent them from deserving an entitlement to that declaration. Whatever the case, it wouldn't be a violation of the trial court's discretion in the matter under this standard of review. And the same goes for common law dedication. If this court found for some reason that 40 years was a reasonable amount of time for an offer to be outstanding and then be accepted based on an unincorporated 911 map and a fire hydrant, then I think this court would still find that it's harmless error under the applicable standard in this state because they're not Sumter County and because the resolution exists. So for 3 independent and mutually exclusive reasons, appellant has failed to show that they are entitled to a declaration of their rights for either a public prescriptive easement or common law dedication. And the findings of the lower court come clothed with the presumption of correctness. Absent clear error, they should not be overturned, and that's why Appellee Ronald Brown is asking this court to affirm all the lower court orders.
Thank you, Counsel.
Good morning, George Angelitis on behalf of Sumter County.
May I ask you the first question about jurisdiction? We had issued an order talking about jurisdiction, and we weren't very specific, and I'll admit that. The concern that I had was that the order, as it relates to the county, simply granted a motion to dismiss, which is normally not an appealable final order. And we weren't very specific when we asked you to address that. But why is this an appealable final order as it relates to the county when it merely grants a motion to dismiss and doesn't enter a judgment in favor of the county?
Well, I think because there are so many implications to the county if this decision is reversed. First, as Mr. Waugh pointed out, if there's a common law dedication that is approved by this court, there is liability that potentially the county could incur. So I think we have a dog in the fight at that point. In addition, the main crux, I believe, as this court has acknowledged, because you spent at least 15 minutes discussing it with counsel, is the issue regarding the resolution. And we should have the right to defend our resolution here. I think that the challenge, one of the challenges that counsel has brought up is the fact that this is a void resolution. And our position is that it's not. We should have the ability to raise that issue before you. I think that's what their whole appeal is. A large portion of their appeal is based on.
Maybe you shouldn't have moved to dismiss. If you wanted to, I mean, it seems to me that.
I did move to dismiss.
I know, but I'm saying, you wanted out, you got out, but you never got a final judgment. Now, but, all right, we'll deal with jurisdiction. You go ahead and tell me about the merits. Why do you think that the First District Court of Appeals, do you think the First District Court of Appeals cases says what counsel says, that is, that the resolution is invalid if there's no finding of public benefit? And number two, if the First District, do we have to conflict with the First District if we say otherwise? And if that's true, does that render it void or voidable?
I don't think that the Bolden case is binding on this court, number one.
Well, we know it's not binding on us. The question is, do you think it's right or wrong? And if you think it's wrong, why do you think it's wrong?
That's a tricky question, because what the Bolden court said was, and I'm quoting from it, 33610 contemplate a finding by the commission that the closing is in the best interest of the public and that this finding should be set forth in the commission's resolution or order. The court does not use the word must or shall. So I think there's a little bit of a disagreement or a conflict in that particular order in and of itself. It doesn't say must or shall, and it doesn't therefore conflict with the statute, which, as you pointed out, only has two requirements: a public hearing and notice. Those two, I don't think there's any dispute that those two particular requirements were met. There was public notice and there was a hearing. And the public was invited to come and speak as to whether or not the resolution was a good idea. And again, I think as you pointed out, the resolution isn't in the record because it wasn't attached. That was another one of the bases of my motion to dismiss, is failure to attach necessary documents. Nevertheless, I don't think you have to find any kind of conflict with Bull Down, because they didn't even require or indicate that it was an actual requirement. They didn't actually find that there was a requirement of the county or the city to go ahead and actually use that language. And since then, as far as I know, the statute hasn't been modified, so the legislature hasn't determined that the Bull Down court changed the requirements of the statute. So I don't think you have to conflict with that court at all. And it's in reliance.
Is there any presumption, I mean, you do apparently a lot of governmental law, is there a presumption that governmental entities act in the public interest? And if so, who would have the burden of asserting that it wasn't in the public interest? And would that require an evidentiary hearing?
I think it would require an evidentiary hearing within the statutory time frame, which is 4 years, which of course didn't happen. But I do think there is a presumption that cities and counties do act in the best interest of the public.
So your argument is, if they wanted to complain about whether or not this was in the public interest, their window to do that was 4 years from the time of the resolution?
4 years from 2002, the time of adoption. That is our argument. And again, the Bull Down court relies on an Attorney General opinion, and in the Attorney General opinion, the Attorney General doesn't even state that it's a requirement. The Attorney General does not indicate that such a determination must or shall be included in the text of the resolution. It just merely states that the county should not vacate a road absent a determination that the general public welfare would benefit from such a vacation. And I believe that the presumption, as you indicated, or that you suggested, does exist already. cities and counties do, I think there is a presumption that cities and counties do act in the best interest of their constituents.
Thank you, Council.
Thank you.
Taking it in reverse order, the Bolden case at 210, just above Head Note 6, when you go to look at the case, we agree that Sections 336.09 and 336.10 contemplate a finding by the Commission that the closing is in the best interest of the public and that this finding should be set forth in the Commission's resolution or order. If you determine that that is not required, I think there is a conflict with the first. Also on the top of page 211, spilling over from 210, whether the county's decision to vacate comports with the best interests of the public at the present time or is merely an arbitrary act that fails to conform with statutory intent governing road closings is sufficiently raised in the complaint for declaratory action to warrant an evidentiary hearing thereon. On that issue alone, this court should reverse. Getting back to Brown, in
But
nearby...
how do you address their statute of limitations argument if your argument has to be that it's void, that the failure to make that finding renders it void?
That's correct.
Okay.
And the reason why there is a split of authority in cases is you're dealing with one that deals with taxing issues, special assessments, and there needs to be some permanence to what the government does so that they're not challenged 20 years later and told you've collected too much money over 20 years, you owe me a huge amount of money. There's a statute of limitations for that. As is pointed out in Boyd's work, that is not applicable to a transfer of property. It's void at the time, and statute of limitations doesn't go to it.
So if somebody tripped and fell and injured themselves on this road, they could go back and seek to get recovery from the county if they could go back and say, here's a reason why the abandonment 20 years ago isn't valid, and therefore the county's still liable for maintenance of this road?
I think those are questions beyond what we have here, Judge, in that there's little indication that the county maintains the road. There are some indications that there have been improvement.
If there was a common law dedication, does the county then assume some duties to maintain, assume some liability for injuries, for failure to maintain, et cetera?
Yes, Judge, I believe they do, and the reason for that is the use of the public is itself acceptance. They're talking about this tremendous amount of time between the dedication and the acceptance, and alleged in the complaint is after the dedication, the public started making use of it and has made use of it to this day. From a statute of limitations standpoint, the issue that you run into is if you were to apply a 4-year statute of limitations, you are then saying that the government can execute a deed, a transfer of property that does not follow statute, and if no one picks it up for a period of time, it's magically fixed. And that is contrary to what Boyd's work says. If the deed is not done right to begin with,
Of course, you don't.
it's not done right.
Yeah, but you've never contended that the county had a fee interest here, that this isn't the same as a deed.
Well, Judge, I would argue that both deal with the transfer of property rights. So,
At best, your argument was that this was either an express or implied easement, essentially, a public prescriptive or common law dedication, which are all easements.
they are, Judge, and they're property rights that go with that. I think a determination when you look at public prescriptive easement and
Well, the
prescriptive
property
use.
rights, but not in the sense that they could be deeded. I mean, the county I couldn't come in and negotiate with the county to buy their easement, do you think?
You're asking about ownership of the property in the county, and what I will say is in an offer of dedication, the offer is made, the property does not sit there in the original dedicator's name until such time as the county says it's no longer used. It's transferred, and the general rule is it's transferred half to one side of the street and half to the other side of the street, which goes to the other issue that the judge presupposed on, which was what should happen if the county does abdicate the road and if that was effective. The last issue that I really need to bring up is the secondary purpose.
No, your time has expired, sir. You're well over your time, so thank you.
Thank you all.
At this point, the court will take its morning break. The lawyers and the